Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. Reminding our internet viewers that questions can be submitted at any time, simply emailing us at speaker@heritage.org. For those in-house, we appreciate that last check that your cell phones have been turned off, as our panelists have dutifully done. And we will post the program within 24 hours on the Heritage homepage for everyone's future reference as well. Hosting our discussion is Hans von Spakovsky, our Senior Legal Fellow in the Ed Meese Center for Legal and Judicial Studies. He also manages our Civil Justice Reform Initiative. He studies the legal aspects of elections, such as campaign finance, voter fraud, voter identification laws, as well as registration and equipment issues. Before joining us, he served 2 years as a member of the Federal Election Commission. Prior to that, he was counsel to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. He's also a former litigator, in-house counsel, and senior corporate officer in the insurance industry. Please join me in welcoming Hans von Spakovsky. Hans?
Well, ladies and gentlemen, I want to welcome all of you to the Heritage Foundation. We are open today, and the reason is, if you can't see this, I'm holding up a penny. We don't even take a penny from the federal government. We're entirely supported by our private members. I do want to welcome you also to the fact that this is the 4th event in our Preserve the Constitution series. This is an annual event with a series of events to celebrate what I think is the greatest political document written in history, the Constitution. And our next event is on Thursday of next week, October 10th, and it's going to be about recess appointments. As you all know, there's a case now before the U.S. Supreme Court on that issue, and we're going to have a keynote address by Senator Mike Lee, and then discussions with John Yoo and Michael Stern. I invite everyone to come to that. Our subject today is political speech and the IRS. And it is a very topical issue. In fact, I just saw a newspaper article this morning as I was preparing for this about an organization called the TeaParty.net, which is apparently one of the largest Tea Party organizations, that just got a letter from the IRS after 3 years of waiting, granting it its tax-exempt status. Now, we all know that the First Amendment was intended to protect political speech and encourage the participation of American citizens in the political life of this nation. Campaign finance laws implemented over the last 30 years have in many ways restricted the First Amendment rights of individuals and associations, and so have the laws, the tax laws, as they've been interpreted by the Internal Revenue Service. Congress is now conducting an investigation of the targeting of conservative organizations who are applying for tax-exempt status and other groups because of their political views and their beliefs, and there are also lawsuits pending over not only the refusal of the IRS to grant that status, but the conduct of the IRS in asking for voluminous amounts of information and documentation to which they were not entitled, even down to questions such as what kind of prayers certain groups were making, what their reading lists were, and wanting the resumes of college interns who had worked at one particular organization and where they ended up going afterwards, absolutely none of which has anything to do with the key question under the IRS law and regulations of whether or not the organizations were engaging in campaign activity. Did the IRS unfairly target these organizations? Was it intentional? Was it an accident? What's the status of the claims and investigations? How far can or should the government go in balancing the interests of protecting and against corruption in the political process, and on the other hand, allowing individuals and associations to fully engage in the First Amendment and in political speech? Do the IRS rules and regulations need to be changed? Is there too much leeway given to the IRS, and is that why we are in the fix we are today? Well, here to answer all these questions are three, frankly, the leading experts in the country on these issues, and I'm going to quickly introduce all three of them and then let them discuss this problem. First of all, we have John Eastman, who is the Henry Salvatore Professor of Law at Chapman University School of Law and the former dean, by the way, of the school. He specializes in constitutional law and legal history. He is also the founding director of the Center for Constitutional Jurisprudence, a public interest law firm affiliated with the Claremont Institute for the Study of Statesmanship and Political Philosophy, and he has filed numerous amicus briefs with the U.S. Supreme Court. He served as a law clerk to Clarence Thomas, Associate Justice of the U.S. Supreme Court, and to Judge Michael Ludig of the Fourth Circuit Court of Appeals. He also practiced law with the national law firm of Kirkland and Ellis. And if you take a look at the list of things he has published, it just goes on for pages and pages, so I'm not going to list any of that, John. He's also the chairman of the National Organization of Marriage, which was, in fact, targeted by the IRS, and they have a lawsuit pending against them because of the illegal disclosure by employees of the IRS of confidential tax information. Cleta Mitchell is a partner at Foley & Lardner and a member of the firm's political law practice. She's an expert on campaign finance law, election and lobbying law, and she is representing a number of the conservative organizations that were targeted by the IRS, including True the Vote, which has also a pending lawsuit against the Internal Revenue Service. She has testified many times before Congress and has served as legal counsel to the National Republican Senatorial Committee, the National Republican Congressional Committee, and numerous federal candidates and committees. She also represented the National Rifle Association before the Supreme Court in a seminal 2002 federal campaign finance law case. Cleta's biography also goes on for many pages because she has accomplished so much in her career, including publishing many articles and books. I will tell you that she's one of the best lawyers in this city, and if you have a case before the FEC or you're going to sue the IRS, I can't imagine anybody better to hire than her. She's a fighter and a principled lawyer, and is one of the most fearless lawyers also, I should say. If you haven't seen some of the tapes of her testifying in front of Congress, you should look them up. Finally, Bradley Smith is the Josiah Blackmore Shirley Nault Professor of Law at Capital University Law School. And in 2010, he received the Bradley Prize. Again, he's also one of the nation's leading experts on campaign finance law, has written books about it, and a textbook, which is now being used in law schools all over the country. In 2000, he was nominated by President Clinton to serve on the Federal Election Commission for a Republican seat on the commission, and he served there for 5 years, including as chairman in 2004. I actually was nominated to fill Brad's seat after he resigned, and I have to tell you that there was a joke running around the FEC when I was there that Brad's ghost inhabited his office because I took over his office, and they said that because of the fact that I tended to vote the same way he did, which was against overregulation and restrictions of the First Amendment. He's been at the Capital University Law School faculty since 1993. He's also taught at George Mason. And actually, he just had a very good commentary on this issue in the Wall Street Journal, which I would urge all of you to read. So, John, we'll start with you.
Okay. Should we do here or?
You can do either one.
I'll do here, so I can read my thing. So I'm going to talk in a greater level of detail and specifics on the particular case that was filed 90 minutes ago by the National Organization for Marriage against the Internal Revenue Service. I'm going to describe what happened and then put that into the larger context of why this is such a dangerous thing we see happening at the IRS. Cleta's going to talk about the same thing that's going on with a number of the Tea Party organizations, and then Brad's going to wrap it up all in a nice bow for us and tell us how to fix all the problem. So we have here up on the screen a copy of Schedule B of our tax return. The National Organization for Marriage is a nonprofit, as every nonprofit does. You have to file a tax return, a 990 form, and make it publicly available. But you also have to attach to that tax form schedules that include the list of all your major donors and their home addresses and the amount they donated. That part of the tax return is not publicly available. Virtually no nonprofit discloses their list of donors for obvious reasons, and it is protected by the Internal Revenue Code as confidentially as your own personal 1040 tax returns. It is a felony to disclose those. Anyway, so last March, this is what shows up on the Human Rights Campaign, the principal political opponent of the National Organization for Marriage around the country. Now, I'm only giving you the cover page of our Schedule B, not all of the donor pages, because I don't want to exacerbate the illegal disclosure of our donor names, but all of those donor pages were on the Human Rights Campaign. This is what showed up. And our eagle-eyed staff at the National Organization for Marriage discovered there was an odd blank across the middle of the page. Let's see if I can bring that up, all right? Note this redaction across the middle of the page. And then our computer forensic guy figured out how to lift the layer of redaction off of the PDF form. And here's the unredacted version. Let me highlight a couple of things. At the top was a header, live return from SMIPS, official use only. Now, according to the IRS manual, this is the language that gets put automatically on every single tax return you electronically file with the IRS upon entering the IRS's internal central information system. It does not exist on the copy of the tax return that we had, obviously. The redaction across the middle of the page that led us to realize that there had been a redaction has the internal IRS Bates number that gets put on automatically with every document that gets filed with the IRS. Now, significantly, IRS computers can only be accessed if you're an employee logged onto the computer and there is a log created of every document you access on that central information system. Right? That's important because it means it's a relatively easy thing to identify who obtained within the IRS the copy of our tax return that ended up on the Human Rights Campaign webpage. And I just want to give you a couple of possibilities here. The chairman at the time of the Human Rights Campaign was Joe Salmonese, who the next day was named as a national co-chair of the Obama re-election campaign. Just one possible coincidence. All right. Another fellow, Stephen Grudnitsky, who's the manager of the IRS Exempt Organizations Office. Here he is with his official IRS card, and here he is at the Human Rights Campaign's Christmas party, the 3 months before our tax return shows up on their page. Now, let me tell you how serious it is. Section 6103 of the Internal Revenue Code provides that the returns and the return information are confidential, and it prohibits unauthorized disclosure or inspection by any United States employee. Section 7213 of the Internal Revenue Code makes it a felony, punishable by up to $5,000 fine and imprisonment by up to 5 years. That's a pretty serious felony. This used to be a misdemeanor offense before Richard Nixon utilized the IRS for his own political purposes, and Congress shortly after the Watergate scandal, enhanced the penalty of this to a felony. We've been unable in the 18 months since this was disclosed to get the Department of Justice to actually act on these felonies that were committed. And as I said, it ought to have taken all of 10 minutes to figure out who did this. But after 18 months of seeking to get the Department of Justice to do its job, we filed a number of Freedom of Information Act requests to try and identify the results of their investigation, if they ever had one. They tried to blame us initially and claimed it was a whistleblower. When it pointed out that we don't have the ability to put those IRS markings on our own tax returns, that kind of ended that part of the investigation. But Section 7431 of the Internal Revenue Code allows for taxpayer suits for damages for illegal disclosure. A statutory damages of $1,000 per disclosure or inspection. And if they were collusive in posting it on the website, you know, that number could get large fairly quickly, given the number of hits that hit on this thing, as well as actual and punitive damages that are available against the United States. And so, like I said, 96 minutes ago now, we filed our lawsuit against the United States under 7431. to get the damages to us, but more importantly, to open up discovery so that we can identify who committed these felonies. And once we've done that, we will be turning the pressure up even more on the Department of Justice to actually prosecute these felonies. Let me tell you what the Internal Revenue Service's position, though, is right now. That because Section 6103 prohibits the disclosure of any tax return or tax return information, and tax return information is defined to include investigations for violations of the tax code. So if you're being investigated for fraudulently filing tax returns, and I conduct an investigation but it doesn't yield any criminal prosecution, that investigation is part of your confidential tax file and I can't disclose it. But they are claiming that because the violation of the non-disclosure provision is in itself an investigation into a violation of the Internal Revenue Code, that the perpetrator of this felony against the taxpayer, the National Organization of Marriage, cannot be disclosed to us, the taxpayer, because that would be tax return information of his own because he was being investigated for a violation of the tax code. I kid you not. And just so you realize I'm not kidding you, this is an exact quote from the Internal Revenue Service response to our Freedom of Information Act request. The release of investigative records is governed by the confidentiality of 6103. Specifically, records compiled pursuant to that investigation, including even the fact of the investigation, are protected return information of the subject of the investigation, the person that committed this felony against us. And therefore, they're not even going to acknowledge that an investigation exists, much less tell us who committed this felony against us. Now, this is a preposterous interpretation of the statute. I suppose textually, technically accurate if you look at this language in isolation, but it renders nugatory the felony provisions, the civil liability provisions, and the protections for taxpayers that this statute was designed to provide. And so we filed suit this morning, and we'll see if the court agrees with this Orwellian interpretation of the statute. Why is this important? Well, we've known for a long time that the fight is no longer about marriage or any particular issues. The fight is about the scope and size of government. And when the government itself is using the powers of government and the levers of government to put a big thumb on the scale of that fight and starts targeting people based on their views of opposition to an expansive government, we've got a serious problem in this country. The non-lawsuit that was filed this morning, I think, is an important step, but only a first step in holding the people responsible for this accountable. And we're going to continue to unravel that chain until we figure out how high up this thing went and demand accountability in office. Because if we don't do that, and they get away with this, then the next election cycle, it'll be 10 times worse. And the election cycle after that, exponentially worse even still. It's important to put a stop to this right now by insisting that the law be enforced in an even-handed way, and that when people commit felonies, that they be called to account for it. Thanks very much.
Well, thank you all very much, and thank you, Hans. Is this on? This is on? Can you hear me?
It is.
Thank you, Hans, for calling us in. I have to tell you that talking about the First Amendment, I would be remiss. Brad was a wonderful commissioner of the Federal Election Commission, as was Hans, who both did yeoman duty, fighting every day within that agency to protect the First Amendment. I would be remiss if I did not take the opportunity to publicly acknowledge the presence of just recently FEC departed Commissioner Don McGann, who absolutely took up the mantle where they left off and fought every day with those bureaucrats, trying to make sure that the agency followed the rule of law and not allowing political considerations to abort the First Amendment. And so I just publicly want to say to Don, you're a real hero to the First Amendment. We're going to miss you at the FEC. And so that is a segue because into, how did this thing happen? John is giving you a case study. I could give in a particular violation of law by the IRS. I can give you additional many case studies. I want to just briefly take a little bit step back and give you a little bit of a broader overview of how this scandal began, what it really meant, and then sort of we can talk later about where I think it's going. Brad will do maybe the 30,000 feet that we all need to keep in mind. But look, I mean, what I do for people when they come to my office, they say, I want to be involved in this policy work, or we want to do this or that activity, whether it's regard to an issue or a campaign or whatever. And so I listen to what they want to do as citizens in exercising their rights as citizens to become involved in the political or policy process. And then I sort of have to figure out, all right, let's see, you fit into this slot that the IRS code has defined. Because in America, at least if you want to do something legally, I don't know how they do it in the black market, but if you want to do something legally, like open a bank account for whatever enterprise it is, you have to give the bank a number. If any of us open a bank account, we give them our Social Security number. But if you are not a living, breathing person, you have to say to the bank, well, we're one of these, and there's this list. You go get a number from the IRS. And every for-profit entity, or even some nonprofit, you just go, you check the box to get your number. You say, this is what we are. I'm a subchapter S, I'm an LLC, I'm a trust or estate. And then you get your number and you take that to the bank. Well, if you want to be a not-for-profit tax-exempt entity, you also have to get a number, and you have to tell the IRS what type of entity you're going to be. Now, let me just say very quickly, tax-exempt means only that the organization does not pay income taxes on the contributions it receives. Tax-exempt organizations pay lots of other kinds of taxes, payroll taxes, unemployment taxes, property taxes in many cases, sales taxes. So it means that you're tax exempt, you're a tax exempt entity, and you have to get permission from the IRS in order to function as to be a 501c3 so that your contributions can be deductible. There's some debate with the IRS says, well, you don't have to actually get permission from the IRS to operate as a 501c4 grassroots lobbying group, but tell that to the state regulators who won't let you solicit contributions from the general public if they don't have a copy of your letter of determination of exempt status as a C4 from the IRS. So, I've been doing this a long time. You prepare your application. Look, these are not on the back of a postcard. There's a form, 1023, if you want to be a 501c3 charitable organization. It is 31 pages long. It has 11 parts, 8 schedules, multiple questions, and a list of documents you have to provide. If you want to be any other kind of 501c entity, a C4, a C5 labor union, a C6 trade association, you file a Form 1024, 19 pages, parts 1 through 4 with 11 schedules. The instructions are many, many pages long, and you fill that out. This is what's published on the IRS website. It's duly promulgated. This is what you are asked to provide. And based upon what you're asked to provide, the IRS Exempt Organizations Unit, headed formerly by Lois Lerner, now retired at our expense, and they review your application and then issue or don't issue a letter of determination of exempt status. Now, that's the only area where you actually have to go to the government and get permission. You don't have to ask permission if you want to open a partnership or an LLC or anything else. You just tell them this is what we are. But here it's Mother May I. You have to go ask permission. Well, before, I call this pre-BOLO, be on the lookout, the pre-BOLO program. You file for a 501c4 and you get your letter back in 3 or 4 weeks. They might ask you a question or two about your application, or if you didn't have your something that was missing that's on the checklist, and you'd get that back 4, 5, 6 weeks. Then a C3 would take a little longer. I always figured it was because, the government contributions are deductible to the donor, and I figured the government doesn't want to lose the revenue, so they make it sure that you really are going to operate as a charitable organization. But still, 2 or 3 months, max. I began to realize in the spring of 2010 that an organization that had applied for exempt status in October 2009 and we'd still never heard anything from the IRS. They cashed our check, because it cost $750 to apply, but they cashed our check in November, but spring, nothing. I don't hear from the IRS until June of 2010 about this organization, and guess what? That letter didn't come from Cincinnati. It came from Washington. I never dealt with anybody from Cincinnati on that organization. And the kinds of questions that they asked, they wanted copies of all the TV ads this organization had run against Obamacare. That's the only thing this organization had done, was lobby against Obamacare. For a 501c4, they could spend 100% of their revenues on grassroots lobbying and direct lobbying. There's no prohibition, no limit. They did no political activity. And then it began to repeat itself over and over with other clients who would fill out the paperwork, submit the application, nothing. I knew something was strange was going on. In June of 2011, after we had sent all of the things that this organization, all the ads this organization had run, I sent a letter to these, I called them my parole officers, because we check in periodically. And, I would say, what's happening? And a year goes by, nothing. And I sent a letter in June of 2011 to the people in charge of this one organization's application that I'd spoken to a year earlier. And I said, let me give you this timeline. And the only thing this organization has ever done is lobby against Obamacare. I'm beginning to think that the only reason we haven't gotten the letter of exempt status is because of their political views. I said, I hope that's not the case, but if it is, please tell me so we'll know what to do next. Well, within 24 hours, there are 3 agents on the phone talking to me, denying that there's anything like that going on. Well, we're working on it. I said, well, you are really working on it, and there's not that much to work on, people. But June of 2011. Fast forward, more clients are coming, nothing is happening, nothing's being processed, we haven't heard anything. February and March of 2012. A whole slew of my clients, along with hundreds of other clients, organizations from across the country, get letters from the IRS with literally 60, 70 questions with parts and subparts from the IRS saying, if you do not answer these questions by the deadline we have given you, your application will be deemed to be withdrawn and you will be treated as a taxable entity. So responding is not exactly voluntary. And that's when it was clear, and all of these letters were pretty much the same, some asking for donor information. So I put together a whole group of these letters and went through and redacted the identifying information, and I packaged them up and went over to the House Ways and Means Oversight Subcommittee and went over to the Senate Finance Committee, and I said, something is going on at the IRS. I've never seen anything like this before. They are clearly treating all of these groups differently than they've ever treated anybody before, in my experience, and you've got to find out what's going on. I go to a meeting once a month with lawyers from on both sides, liberal and Republican, Democrat, conservative, and we are practitioners in this area. I take these redacted things and I said to my Democratic colleagues, are your organizations or clients getting these letters? And they're going, oh, this is really something. No, we've never seen it like this before. And so, fast forward, nothing is happening. Fast forward, I forgot to tell you that in October of 2011, I talked to an agent in Cincinnati who was handling the case for one of my clients, and he tells me, all of those have been moved to Washington. He said, well, I'm waiting for there's some people in Washington who are looking at all of this. So we supplemented this one application, submitted it, the supplement. I called him in, and I said in the cover letter, I know you've said that this is being reviewed in Washington. Please forward this to whoever in Washington needs to get it. I called him just before Christmas of 2011 and said, so have you heard anything back from Washington? He goes, lady, there's a task force in Washington. They're handling all of this. It's really out of our hands. So imagine my surprise in May of this year when Lois Lerner announces that this is a couple of rogue employees in Cincinnati, which, actually I knew that was a lie. Because I had seen these letters, some of my clients, they were coming from California. I'd had letters from Ogden, Utah, and Washington, and on and on. Now, let me just tell you, a couple of things. How did this start? It started specifically because I think it's part of the way in our culture that it's okay to beat up on conservatives. Whether you're on the college campus, whether you are in a big company, a big law firm, a big accounting firm, anything big in America, conservatives are just weird oddities. And so it's okay to beat up on them and to say ugly things to and about us. And we're just supposed to conform. I mean, we're the hateful people, but they say all the ugly things about us, and we're supposed to not object. So you have a situation then where, quite specifically, the President of the United States, and it's interesting, if you look at the interim report that Chairman Issa has issued a couple of weeks ago from the Government Oversight and the House Oversight and Government Reform Committee, the interim report, when they've conducted about 24 interviews at this point of IRS employees who said, well, we were getting all these letters from Democratic members of Congress telling us to do something about these groups. And the President of the United States was publicly calling on the IRS to do something about these groups. So guess what? They did. They did. And if you look, the report that was issued in November of 2011, it's a sensitive case report, 162 organizations, almost all of them conservative, sent from Washington to Cincinnati saying, these are the ones we want you to look at. All my clients are on it. Somebody said, Cleta, maybe you're the one they were targeting. But that's kind of a scary thought. But look, I mean, I could go on about this a long time. A couple things I want to mention. This is what happens when you depart from the rule of law. I don't want anybody to miss that this is lawlessness. We always say growing up, as Americans, we're a nation of laws, not of men. What does that mean? It means that everybody has notice of what the law is, what the government, how the legal standard by which we're going to be treated and judged, and that the law will treat all of us the same, right? This administration has made a mockery of the principle of the rule of law, not just at the IRS, but writ large in many agencies. It's government by cronyism. It's the worst. It is a reminder of all the things you used to read about the former Soviet Union and how the commissars got treated one way and the rest of the people got treated another way. These people lie. Lois Lerner, I mean, she is a liar. That's the nicest thing I can say about her. But they knew, if Doug Shulman, the commissioner of the IRS, when these members of Congress started asking a year ago, Doug Shulman testified to Congress, there is no targeting. They knew, Lois Lerner, Stephen Miller, all of them knew if they didn't know that day, they knew within weeks, that his public testimony to Congress, to the people's elected representatives, was false. I thought people who lied to Congress got prosecuted. Ask Roger Clemens. But has there been any prosecution of any of those people who lied to Congress? Has there been any prosecution of the people who broke the law and released NOM's Schedule B donor information to the Human Rights Campaign, for Pete's sake? And somebody says, the only thing we know is what they've said in these hearings and said, well, it was inadvertent. Okay, it was inadvertent. It was a mistake that we released NOM's Schedule B donor information to its mortal enemy, the Human Rights Campaign. Yeah, that was just kind of an accident.
Redacted so we could hide it.
Right. They've lied to the American people. There are felonies that have been committed. There is no enforcement. The President of the United States had his I'm Mad Too press conference on May 15th about how he was going to have Eric Holder and the Justice Department look into this and do a complete thorough investigation. I've never heard a word from the FBI. None of my clients have ever heard a word from the FBI. I mean, this is the pretend investigation of what they now call as a phony scandal. This is a serious, serious situation where, and I think the American people understand it. They don't believe anything will come of it because they don't think anybody will be prosecuted. And I think that it has done great damage to the notion of the rule of law and the First Amendment protections of the American people to form together in organizations and citizens groups to express their political views. So there's a lot more to come, but that's my overview.
It should be on.
It's on.
It's,
Okay.
yeah.
All right. Well, anyway, it's a pleasure to be here. It's always a tough act to follow, Cleta. Hans did not mention in the introduction, which did not go on nearly long enough, but that I'm here today actually as a representative of also of the group that I founded after leaving the FEC called the Center for Competitive Politics. But I do want to point out that in an effort to assure that we do not have problems with a particular government agency that has been under discussion here. We have recently changed the name to the Nelson Mandela Center for Gay, Lesbian, and Bisexual Rights, Immigration Reform, and Competitive Politics. What I want to do today is as was suggested, kind of pull back and say, how did we get here? How did the IRS get into this business in the first place? And what I'm going to suggest, of course, is that it has been a very conscious effort over a long period of time by folks in the campaign finance reform regime or movement to push the IRS into the regulation of politics. And the results that we've seen are, in some respects, the inevitable result of that kind of role for an organization that's supposed to be engaged in neutral revenue collection. I'm going to start back with some campaign finance law, and if you'll bear with me, we go back into the 1970s. Now, into the early 1970s, political committees essentially had no tax status whatsoever. The IRS just figured they didn't have any taxable income, and therefore they just didn't report. They weren't anything. They weren't a C4, a C6, a 527. They were nothing. They were just there, right? But the IRS began to notice that some political committees would earn some money from investment income and so on. And that was revenue that normally would be expected to be taxed. And so the IRS asked Congress to fix this, and Congress did this by creating a section of the tax code called 527, which would apply to political groups, everything from Brad Smith for dog catcher to Barack Obama for president and the Republican National Committee and PACs and every kind of campaign committee like that is organized under Section 527 of the tax code. But not all organizations formed under 527 are regulated by the Federal Election Commission. They're only regulated there if they expressly advocate for the election or defeat of particular candidates. So we'll come back to that in a minute. Now, at about the same time, Congress passes the Federal Election Campaign Act, and in 1976 that goes to the Supreme Court in Buckley v. Vallejo. And one of the elements that was challenged were the broad disclosure requirements that would require people to disclose to the government their political activity, a form of their political activity. And the Supreme Court felt that there were some compelling government interests for requiring political activity to be disclosed, at least donations to members of Congress and to political committees, groups organized solely for the purpose of electing candidates, again, such as Smith for Congress or what have you. And so the court upheld the disclosure provisions, but it did so only after very substantially narrowing them. In fact, it's fair to say that probably most of the disclosure that would have been required under this 1974 Act was actually tossed out by Congress, even as they upheld the provision. And they did that by saying the only people who have to disclose their members and donors and information on those members and donors, right, are these political committees, groups devoted to electing candidates to office, right? And as well, you have to report your independent expenditures that specifically advocate the election or defeat of a candidate for office. So if a group, say the Sierra Club, or let's suppose the Heritage Association, well, Heritage couldn't do it because it's a C3, but some group that's a C4 just decides, Heritage Action, I guess, could do it as a C4. So if Heritage Action decides, we're going to run an ad that says, vote for Ted Cruz for Congress, right? Or for Senate, or whatever we want, office we want to put him in next. Probably don't want to step down to Congress. But, so they want to run this ad, vote Ted Cruz for Senate, right? They would have to report that ad that it was paid for by the Heritage Foundation. And if somebody gave them money specifically to run that ad, they would have to report the name of somebody who gave them money to run that ad. But otherwise, all this disclosure information was off limits. And the court here relied on a long series of cases from the 40s, 50s, and 60s, many of them dealing with the civil rights movement. The landmark case, the one you're most likely to have heard of is NAACP versus Alabama. And just the name of that case can give you some idea what was up. Southern states and governments were trying to force the NAACP and other civil rights groups, and in some cases labor unions and various other types of organizations, to disclose their donors and members, knowing that if those donors and members were publicly disclosed, they would quit donating and being members. They would do that either because they would fear official retaliation from the government, or they would fear boycotts, vandalism, physical threats, all kinds of things. And as the court noted, you can often silence people simply by trying to harass them, and whether it's government or allies of government. So Buckley really restricts the disclosure regime while allowing for full disclosure of contributions that actually go to candidates and actually go to political parties and actually go to PACs. So we move on now as we start going on. Now, a lot of groups that are organized under Section 501c4 of the tax code, this is, again, the organizations that can do lobbying, that do public education, right, but can also do some political activity on a bit of it. These kinds of groups are doing a certain amount of political activity. The IRS decides in the 1980s and 90s, especially in the 1990s, you know, we wish you guys would register under this Section 527 of the tax code, right? Because that way we don't really have to police whether you're doing more than half of your activity on political activity or not, right? If you just register under 527, you're fine. Now note what's important here too is that for these committees, it doesn't matter. It doesn't matter. If you're a 501c4, you can be taxed on certain investment income and so on. If you're a 527, you can be taxed on the investment income. In either case, though, you're not taxed on your contributions that are given to you, right? So there's no tax break for being a 527. In fact, there's really, as a practical matter, no significant difference at all for the taxpayer. It's just a question of, you know, whether my middle initial is A or B, but, you know, arose by any other name, right? Who cares? And so a lot of these groups organize under 527 of the tax code. Now, at this point, some of these groups are doing political spending. A lot of them on the left. For example, some of you may remember the NAACP again running ads just prior to the 2000 election, reenacting the death of James Byrd, a black man who was dragged to death by white racists behind a pickup truck. And his daughter came on, and they had a reenactment of this in grainy filmage. And his daughter came on, and she said, when George Bush vetoed hate crimes legislation in Texas, it was like my father was killed all over again, right? And this was 1 week before the 2000 election, and she says at the end of this, she says, so call George Bush and tell him to support hate crimes legislation, right? And because she does that, it's not a campaign ad, right? I mean, we laugh, but that's something that has always been very important on our side, is that people need this express line to know whether what they're doing is going to get them subject to all these regulations. But what I want to point out is that this is not something new or foreign. In fact, as a result of this, Congress decides they want to do a little bit more. And in 2000, they require 527 organizations to disclose their donors to the IRS. Now, what they were doing here is trying to get around the provisions of the Buckley decision in the campaign finance law that said you can't require disclosure unless a group's primary purpose is electing candidates. And this Congress says, well, they went to another decision called Reagan versus Taxation Without Representation, in which the court had held that if you got tax benefits from the government, like a C3 organization, then you could be required to withdraw from political activity or perhaps be subject to other regulation. In other words, regulation that you couldn't be subject to because of your speech, you could be subject to because of your tax status. Now, taxation without representation involves a C3 organization, but there's some loose language in there suggesting that maybe C4s get a tax benefit simply because Congress doesn't count contributions to them as taxable. That seems a little far-fetched. It's hard to figure out how that would be taxable, indeed, and why there would be any taxable income at the end if the group simply spent all that money, as that would presumably be their business activity. But nonetheless, there's some loose language there, and Congress used that to start requiring 527s to disclose their donors. So what happens then is over the next decade, groups begin to reorganize back again as 501c4s, precisely so that they don't have to disclose their donors, right? They're back into the category where they don't have to disclose their donors. But this puts the IRS back in the position of having to say, well, do you qualify for C4 under C4 or not? So this was a conscious effort by the campaign finance reform community to use the tax code to try to silence political speech that they were not allowed to silence directly under the Federal Election Campaign Act because of the Buckley v. Vallejo decision. I hope at this point I haven't either lost everybody or bored everybody to tears. But you ought to be getting a kind of a general picture. This renewed itself then after Citizens United in 2010. Citizens United comes down and the court says corporations can spend. And the court also says, or the Court of Appeals says just a couple weeks later in a case that the Center for Competitive Politics brought along with the Institute for Justice called SpeechNow.org versus the FEC. The Court of Appeals in a 9-0 decision says you can't stop people from pooling their resources in unlimited amounts. That's what creates essentially super PACs. Now, you'll remember the reaction. The Democratic Party flipped out. The same week that Citizens United came down, they lost the special election for Ted Kennedy's seat in Massachusetts. And I think at that point it dawned on leading Democrats for the first time that, hey, the idea that this is going to get more popular doesn't seem to be working. We could really be in trouble in the next election. And of course, Democrats have this view that big business is always behind Republicans, which isn't really true, but that's sort of their idea. They envision Citizens United with Exxon spending $1 trillion or something, these ridiculous kind of zombie apocalypse scenarios. But that's what they believed, and they saw that Kennedy lost the seat, and they freaked out. They said, we've got to stop this. How can we stop these people from expressing their views? They introduced something called the Disclose Act in Congress. Chuck Schumer, when he introduced this, the lead sponsor, said the purpose of this bill is to deter the other side. He said, quote, the deterrent effect should not be underestimated of forced disclosure on people. This is because it combines with activism, increasing activism, which John's group has been subject to repeatedly, of left-wing organizations to simply harass, vandalize, boycott donors to conservative causes. And we could go at length into that. I won't do that, but that's a growing issue. Media Matters, David Brock's group, has intentionally made clear in fundraising pitches their intention to expose donors so that other left-wing groups and they can organize boycotts of these conservative donors and try to get them to stop speaking. All right. So the goal became, when the Disclose Act was defeated, was to force these groups that are operating under 501c4 to operate under 527 again, where their donors would be disclosed. And hence, you get the slowdown of 501c4 applications. We're not going to approve you as a 501c4 because you could do all the same stuff as a 527, but then we'd be able to get your donors released, and you would be subject to potentially official and almost certainly unofficial harassment in the future. Meanwhile, within this time frame, numerous Democratic congressmen and senators wrote repeated letters to the IRS urging them to investigate conservative groups, in some cases by name, as to whether they were in fact meeting their tax status. This should not be forgotten. The president himself repeatedly talked about the possibility that these groups were funded by foreign money and such allegations like that, totally unsubstantiated. Again, the Center for Competitive Politics has a wonderful timeline, interactive timeline of this on our website at campaignfreedom.org. If you really want to see all these speeches when they were made and actions taken by the IRS and letters from member of Congress telling the IRS to crack down on these conservative groups and so on, it's a wonderful resource, and I encourage people to use it. Now, I need to wrap up here, so let me just make a couple of points about the arguments that are made about whether these groups need to register under 527. First, as Cleta and John pointed out, generally speaking, they probably don't. And moreover, the idea that they should be examined before they've actually done anything seems backwards compared to how we operate normally. Secondly, we need to remind ourselves that there is no tax break for these groups. One of the things that's often being said by those who are defending the IRS is, well, these groups get a tax break. We need to make sure they're complying with tax status. But they don't get that. Bill Nelson, for example, the senator from Florida, actually said to the IRS, he yelled at him at a hearing, how could you allow these tax breaks funded by the taxpayer to be spent on these political campaign expenditures? But there were no tax breaks. The amount of revenue going into the government doesn't matter at all with what category these groups are put in. And this has been picked up by liberals in the media. Jeffrey Toobin had a big piece in the New Yorker earlier this year in which he noted, in return for the tax advantage, groups must refrain from traditional partisan political activity. First, it's wrong. They don't have to refrain from it. It just has to be less than half of what they do, not their major purpose. But second, they don't get a tax advantage for it. So we've got this kind of problem going on. The left knows this. They have. This is no secret. MoveOn.org is a 501c4 organization. Oh, they're not political. No. People for the American Way is a 501c4 organization. NARAL Pro-Choice America is a 501c4 organization. The Brady Campaign for Gun Control is a 501c4 organization. No Democratic senators have ever written, to my knowledge, a letter to the IRS saying, we really would like you to investigate this Move On organization. It seems to me they're doing a lot of pretty political stuff. They're not interested in that. This is clearly a partisan action. And an atmosphere is created when the President of the United States and high-ranking members of the majority party in the Senate are making these kinds of allegations that these groups are operating in violation of the law. And again, on our timeline, you'll see specific quotes actually making that allegation very specifically, not by implication. And so you naturally are going to get a bureaucratic agency that's going to say, okay, this is the important government policy at this point in time. So even if there were not any possibility of, foul motives by any employees at the IRS, okay, and, if we gave the IRS every benefit of a doubt, at least to all of the individual employees and their willingness to do their job in an even-handed, nonpartisan manner, what you're going to have is when you put the IRS into this position, right, and you have leading members of Congress and the White House consistently saying, this is important, you got to deal with this, these people are violating the law, you are going to get partisan investigations that will take place over time. Now, I want to conclude with one final quote that I think is interesting, because one of the things the statute for 501c4s says that groups that are 501c4s must be engaged exclusively in social welfare activities, right? Now, social welfare activities is not defined by the statute. And one question one might have is, what is a social welfare activity? I liked Representative Javier Becerra, a Democrat from California, who noted that 501c4 status should be reserved, quote, for something good, not groups that are in business to do politics. Now, this is a man who has spent pretty much his entire adult life in political office, in elected political office, right? And I think it brings up, a key point here. Even if one were to accept that argument there that is made, that these groups must be engaged exclusively in social welfare, why isn't social welfare promoting the public good through political action, educating the public about candidates and issues? And this goes to the big picture of campaign finance reform and now how we're using the IRS to try to get there, which is this attack on political activity as something that is inherently bad, self-serving, and something you should be sort of ashamed of. And so in this way, the IRS scandal comes back full circle with its origins in the campaign finance movement. Thank you.
All right, we do have time for questions. If you would, please wait for the microphone because we are broadcasting this live on the internet. And I would ask you, if you would, to ask a question instead of making a speech, so that everyone can get the benefit of the answer. And I will take the moderator's prerogative and ask the first question, which is, does any member of the panel have a recommendation for a change in the law or regulations to prevent what happened from happening again?
Well, there are a lot of things that I would recommend, but I think the first thing that needs to be done is to just abolish the exempt organizations unit altogether. I don't think you ought to have to go and ask the federal government if it's all right for you to be, whether it's a social club or a citizens organization or a charitable organization. I just don't think that you should do that. And, look, I mean, you don't have to ask somebody if you're going to be a corporation. You don't have to ask the federal government. You just have to operate within the applicable law and applicable provisions of the tax code. And I don't think, when I was growing up, Red Book magazine was a woman's magazine, and they would have every month this feature called "Can This Marriage Be Saved?" about these two, husband and wife who hated each other. I don't think the exempt organizations unit and that whole notion of seeking permission from the federal government to operate it as an tax-exempt entity can be saved. I don't think it can be saved. I think it gives the government too much power. And secondly, David Keating is in the back of the room, and Brad's talked about the new Nelson Mandela Center for Competitive Politics. Are proposing that there be you've heard there are some people who are proposing what they call the Bright Lines Project, which is to define what is a political activity, except that their bright lines are so fuzzy. The Center for Competitive Politics is working on a proposal to very narrowly and specifically define political activity and to limit it to expressly advocating election or defeat of a clearly identified candidate. And if that were to happen, that would be huge, because, you literally have the federal government and the IRS and the FEC regulating whether or not a citizens group can have a candidate for them. and invite candidates for office to come and speak. And, what I tell clients is, well, just invite the bad guys to come too. They're not going to come, but then you've got a letter. But that should not be the government's issue. The government has no business telling a group of citizens who they can and can't invite in to hear about issues. And we're down to that kind of myopia with this regulation of what should be protected political speech.
And as bad as it is, it's worse when the discretion available to the enforcement agencies is so broad that they can target certain groups and not others. And that's why very clear lines are important. I'm reminded of the old Soviet Union, which has a brilliant and strong First Amendment provision in their constitution. Right? Nobody ever got prosecuted for speech in the Soviet Union, but you did get prosecuted for eating meat that you bought on the black market. Right? And how did we know that you bought on the black market? Because the government ran the black market, and but they wouldn't prosecute everybody for eating meat from the black market. Only those that spoke out in ways that they didn't like. We are very close to getting to that kind of thing. The second change that I think you need to have: look, the federal statute makes it a felony to disclose this information, right? And that means you have to rely on the Department of Justice, which is now implicated in the administration that caused this in the first place. The fallback position is for taxpayers to be able to bring their own civil suit, but only against the United States, not holding the individuals that did this accountable. In the United States, at $1,000 a pop on the disclosure, that's how half of a second or a millisecond of the federal budget is that. That's no deterrent for what happened, and yet it seems to have been overlooked. We're going to fight this in the courts, but we think you ought to be able to go after the non-government folks personally who colluded with the IRS to disclose our tax returns, to set up the harassment and intimidation campaign, kind of not at the same murderous intent that happened in NAACP versus Alabama, but you look at the evidence that's come in on the Proposition 8 campaign in California and the intimidation there. This is serious stuff, and the more they succeed in shutting down political opposition as a result of these tactics, the more they will deploy them, and we have got to hold them personally accountable. And making sure that statute that allows for civil liability can be used against those organizations as well, I think is critically important. I think it can. We're going to find out in the court, but if it can't, then we need a fix on that too.
Brad, do you want to address that? No. All right. Questions? Yeah, right on the end over there.
Have you thought about asking Congress to also extend that so that you could go after the individual employees at the IRS?
Yeah. Yes. We're gonna try and do that anyway. I'd like to be able to do it under the existing law if we can get a judicial ruling that law covers it, because otherwise we're going to have ex post facto things, and the guys that did this action against us will be held. Well, the statute's now been changed, but after we did this illegal conduct.
What about following Bivens actions?
Well, yeah, there's very good question. The question is whether Bivens, since there is a specific statutory authority, does that provide the exclusive route? But that's one of the reasons we got the lawsuit pending. Those questions are unanswered, and we're over in the Fourth Circuit in the Rocket Docket for a reason. We want to get these things answered quickly.
Well, let me mention a couple of the other lawsuits that have been filed against the IRS, and I think that this bears watching, because I represent True the Vote in the case against the IRS, and we have named individual employees of the IRS, Lois Lerner et al., Doug Shulman, Steve Miller, Steve Grudnitsky, and we've named them both in their official and their individual capacities. Now, let me tell you an interesting thing. We've brought, one thing that you might be interested to know, which we learned at a status conference a week ago, is that we, the taxpayers, are paying not only for the Justice Department to defend the IRS, but we are also paying the law firms that have been hired to represent these IRS employees in their individual capacities. But here's an issue. One of the claims we brought is a Bivens claim, because you can sue your local police department for violation of your constitutional rights. You can sue a state government employee for violation of your constitutional rights. Suing a federal employee for violation of your constitutional rights, not so easy. There are some conservative legal scholars who've said, well, we think that the Bivens principle is dead. The Bivens principle being that the Supreme Court actually has ruled that, yes, you can. A citizen can sue a federal employee who violates your constitutional rights. And that was Bivens versus 6 unnamed narcotics agents. But we'll see. We'll see. Can we sue individuals? And here's an even bigger question. One of the claims in the True the Vote, one of the counts in the True the Vote case is these people at the IRS and the government, the IRS violated the Administrative Procedures Act, which sets forth that if you're going to process an application for exempt status, there are applications that are published, there are rules of here's what you're supposed to submit. They went way outside of that. We have no idea what standard they were using. Hell, they didn't know what standard they were using. Asking for all this other information. So we've tried to say this violates, the reason the Administrative Procedures Act is in existence is to say that citizens are entitled to notice of what the law is and due process when they appear before the government. None of that was available to, those rights were violated as it relates to True the Vote. But here's the question. If we find in going to court that the judge and the appellate court say to us, well, it's the IRS. They can violate your constitutional rights if they want to. They can depart from the Constitution if they want to. Individual employees can violate your constitutional rights. The agency's not held to have to comply with the Administrative Procedures Act. If all of this, and the government's now moved to dismiss all of this, right? Because they decided to grant True the Vote C3 status after 3 years. But they say, okay, now it's moot. Dismiss everything. But I'm telling you that and there are other cases that have also been filed, and if we find in these cases that these judges say, you can't sue the IRS and you can't sue any agents, I can tell you one thing. We better be back before the Congress, and the Congress needs to deal with the fact that there is a federal agency which seems to be able to both believe and to do, to violate the constitutional rights of the citizens to avoid complying with the rule of law, and there's nothing we can do about it. That'll be a congressional fight.
Hey, Hans, one real quick point that's relevant to both of the last questions that hasn't, I think, come out, which is just the current test the IRS uses as to whether you're engaged in political activity, which they use to then deny you your tax-exempt status, is a totality of the facts and circumstances, right. Which is basically saying whatever we sort of want to do on whatever arbitrary basis we want to do it, at least when, again, put in the hands of people who either are knowingly mendacious or not doing their job fairly, or people who simply feel a lot of pressure to say, yeah, this is the important government interest at this point in time. These people are a threat.
All right, we have time for one more question. Right there.
Hi, Eric Nippon with the Beckett Fund. We've, another situation that we've been hard at work on is the HHS mandate. Another example of IRS being involved to help sort of pressure groups. We've gotten a lot of traction on this issue. I think it's helped a lot to have a website that is a clearinghouse for summarizing the issue and the status of the various lawsuits. Is there something similar on this issue?
No, but we need that. And we actually have been talking about the need to do that. It's hard to do everything, but we definitely need to do that.
Cleta and I are both on the board of the Act Right Legal Foundation, and we've now created a IRS litigation fund and page there. The lawsuit that was filed this morning, is Jason still here, or did he step out?
Jason's right there.
Jason Torchinsky is our co-counsel, local counsel in Virginia, doing that. He just fresh in from the courthouse, so thanks very much. That suit is there, and I think it's a good idea to start putting the other suits. True the Vote, I think, is up there as well, but we can become a clearinghouse on the many others that are going on as well.
And of course, the government has moved to dismiss the case that was filed in Cincinnati by Northern California Tea Party group. There are a number of plaintiffs in that case. The government is basically arguing that all of these cases need to be dismissed because actually they're the IRS.
All right, well, please thank every member of our panel for coming today. And please come next week, and if you didn't get a copy, we do have a paper we've released today from our legal center on this issue, so you can pick up a copy outside.